our concern about the use of acquitted conduct and how it affects the sentencing system. Why I've said Congress might need to look at it, although I've also pointed out individual district judges can look at it, is because under the current system, sentencing judges have wide discretion in picking sentences, so it's hard for a appeals court to say that you've infringed your discretion, given some of the case law of the Supreme Court, which grants that discretion. But I don't like the practice, and I've made that clear in my opinions, so I'm just repeating my opinions here because of the unfairness and perceived unfairness of it.
Okay, this committee has been chasing an elusive deal on criminal justice reform for quite some time now. One particular focus of mine in this area has been mens rea reform. Without adequate mens rea protections, that is, without the requirement that a person know his conduct was wrong or unlawful, everyday citizens can be held criminally liable for a conduct that no reasonable person would know was wrong. Critics of my legislative efforts to bring clarity to mens rea requirements claim the effort is a ploy to get corporations and white-collar defendants off the hook. But stronger mens rea requirements protect the liberty of all defendants in the criminal justice system, the vast majority of whom are not corporations or white-collar defendants. We've written about the importance of mens rea requirements, including in cases involving unsympathetic defendants like an armed robber or a convicted murderer. Why, in your view, are mens rea requirements so important?
Mens rea requirements are important, but because, Senator, under the Due Process Clause and the precedents of the Supreme Court, it is not right to convict someone based on a fact they did not know. It's just an elemental point of due process. Justice Jackson described this principle in his famous Morissette decision that he wrote. It's as elementary as he said, as the school child's "I didn't mean to, I didn't know." And if someone truly didn't know a fact that that's relevant to their conviction, to nonetheless convict them is contrary to due process. I've seen cases where a mandatory minimum sentence was elevated from 10 years to 30 years, a 30-year mandatory minimum based on a fact that the defendant did not know. I dissented in that case, in an in-bank case, joined by Judge Tatel, who was an appointee of President Clinton to our court, saying that, I wrote a very lengthy dissent about the history of mens rea and just how much of a violation of due process I thought had occurred in that case. That was not a sympathetic defendant, given what he had been convicted of, but I thought it was a complete violation of due process and principles of mens rea that were long-standing from Morissette to give him a 30-year mandatory minimum for a fact he did not know. I have also joined an opinion and wrote a separate opinion reversing a murder conviction of someone where the jury instructions were unclear about the mental state of the murder. It was a question of manslaughter versus second-degree murder. That would have had a huge difference in the defendant's sentence. And I wrote an opinion saying this was not an especially sympathetic case given the facts, but the jury instructions were flawed on the issue of the mental state. And my exact line was, I'm unwilling to sweep that under the rug. And that's how I felt about that case. There was a dissent in that case, but I was in the majority reversing the murder conviction in that case. No matter who you are in my court, if you have the right argument on the law, I'm going to rule in your favor, and mens rea is foundational to due process. I've written that repeatedly, and I share your concern about mens rea reform, Senator Hatch.
Well, thank you. I have one last question. Some people seem to think that religious people should not work in government because they swear allegiance to their church, not their country necessarily. I have faithfully served in this country for over 40 years, and I believe I'm a religious person. Now, religion is also a big part of your life. You went to Catholic school, your children go to Catholic school, and you regularly attend church and serve a church-supported soup kitchen. I know that religious faith is a personal subject, but I'd like to hear from you how your private beliefs affect your public decisions. Can you be devout in your faith and still uphold the law?
Senator, my religious beliefs have no relevance to my judging. I judge based on the Constitution and laws of the United States. I take an oath to do that. For 12 years, I've lived up to that oath. At the same time, of course, as you point out, I am religious, and I am a Catholic, and I grew up attending Catholic schools. And the Constitution of the United States foresaw that religious people or people who are not religious are all equally American. As I've said in one of my opinions, the Newdow opinion, no matter what religion you are or no religion at all, we're all equally American. And the Constitution of the United States also says in Article 6, no religious tests shall ever be required as a qualification to any office or public trust under the United States. That was an important provision to have in the founding Constitution to ensure that there was not discrimination against people who had a religion or people who didn't have a religion. It's a foundation of our country. We're all equally American.
So, thank you, Mr.
Certainly. Thank you, Mr. Chairman. And as I mentioned to you earlier, I have a number of letters that ask consent to be placed in the record, as well as the emails that were declassified, I think some at 3 o'clock this morning, that they be placed in the record.
Without objection, so ordered.
Thank you. And I know there was claim this morning the committee was following my precedent, Judge Kavanaugh, but not so. For Justice Kagan, we had 99% of their documents for a time at the White House. And, of course, we have less than 10% of yours. And there were 860 documents designated as committee confidential by the nonpartisan National Archives. That was discussed with both the Democrats and Republicans on the committee. Nobody objected to that. But let's go to follow up on our questions yesterday. We discussed the fact that while you worked on nominations in the Bush White House, you received stolen material from a Republican Senate staffer named Manny Miranda. I thought it was a digital Watergate. He stole 4,670 computer files from 6 Democratic senators. He was doing this in an effort to confirm some of President George W. Bush's most controversial judicial nominees. They were some of the most contentious fights of the day, and this Republican stole 4,000. I also asked about him sending you, quote, intel with extraordinary detailed specifics about what I was going to ask a highly controversial nominee just days later, something I never said publicly. I also asked about you receiving a draft, a non-public letter of mine, before any mention was made public. You testified you didn't recall anything specific, but you thought that the sharing information between staffs was common. So let me ask you this. Has anyone told you what any Democratic senators have been advised to do by our staff at this hearing?
I think there's been a lot of...
Tell the truth.
There's been a lot of discussion about what individual senators might be interested in, and when I met
I really want to hear what you have to say, Judge, what protesters have to say. Please go ahead. Have you been advised, have you been told what any Democratic senators have been advised to do by our staff at this hearing?
Right. So when I met individually with the 65 senators, including almost every member of the committee, a lot of the senators, a lot of you in the meetings told me issues you were interested in. I think your staff was probably talking to...
Has anybody said to you, for example, Senator Leahy's staff is asking him to do this at the hearing tomorrow?
Well, I think you yourself told me what you were going to ask. So
I try to give you a good heads up, and I appreciate the meeting. But has anybody else told you this is what Lady staff is asking at the hearing tomorrow?
again, I think this might be a different kind of process because you all were very transparent when I met with you. I'm looking around and saying, here's what I'm focused on and here's what I'm going to ask you at the hearings. And it's turned out you were accurately telling me your concerns.
Okay. And you're saying that's normal, but did anybody hand you anything marked highly confidential
for this
about any one of these senators?
No, I'm not remembering anything like that, but you all did talk about the issues. In other words, there are no surprises. They're not no surprises, but there are, you gave me a basic concerns and issues you
I
want
want to make sure we're clear on this. Nobody handed you something marked highly confidential, but that is the material you received from Manny Miranda. For example, on July 18, 2002, days before an extremely controversial hearing for Fifth Circuit nominee Priscilla Owen, Mr. Miranda sent you an email with the subject line, highly confidential. Informed you that Senator Biden's staff was asking him not to attend the meeting that day. On March 18, 2003, Mr. Miranda sent you several pages of talking points that were stolen verbatim from Democratic files. The talking points revealed what arguments Democrats were making on another controversial nominee, Miguel Estrada. The subject line of the email stated it was not for distribution, meaning Mr. Miranda was asking you not to share the information. This has now been, as of 3 o'clock this morning, made public. So yesterday when I asked you about these specific events, you said you didn't have any recollection. So I'm not going to ask if you remember receiving this email. I'm going to ask you this. Why would you ever be asked to keep secret Democratic talking points if they were legitimately obtained?
I am looking at these, Senator, and it says, for example, it looks like that Biden staff is asking him not to attend the hearing. I don't know why that.
But look how you received it.
I know, I don't know why that's even confidential because
whether it is or not, would you consider that somewhat unusual to be receiving from a Republican staff member something marked highly confidential, telling him what he's found out the Democrats going to do?
Well, as I explained yesterday, Senator, my understanding of this process is that the staffs do talk with one another, that they're not camps with no communication. And that was my experience when I worked in the White House. And so it looks like Biden's staff is asking him not to attend the hearing would have been pretty standard kind of information that would be.
Not really. You read this, I would be amazed if somebody handed me a memo saying this is a confidential memo that Senator Grassley's staff is prepared for. I know I would not read it. I'd be on the phone immediately to Senator Grassley say, I'm bringing something over that just arrived to me. You better take a look at it. But you received, on July 28, 2002, an email from Manny Miranda that said, my staff distributed a confidential letter to Democratic councils, not to Republicans. Mr. Miranda said, I received that letter in the strictest confidence. You were asked explicitly by Mr. Miranda to take no action on the email without his further instructions. He never asked him how he obtained the letter sent in strict confidence to me. And then July 30th, 2002, you received an email from Miranda saying they had on 100% info that I was convening a meeting about a controversial nominee. And then further in August 13, 2002, emailing obviously taken from my internal emails what I was going to do. Did any of this raise a red flag in your mind?
It did not, Senator, because it all seemed consistent with the usual kind